Hello and welcome to our latest Fenwick Elliott webinar, our 13th, and also our last before we take a short summer break. I'm Jeremy Glover, and today I'm joined by two of my fellow partners, Karen Gidwani and Lucinda Robinson. Karen, who's been with Fenwick Elliott for almost 20 years, has a wide range of experience working across the construction industry, both in the UK and abroad. Although, as the Legal 500 has pointed out, she has a particular wealth of experience in the offshore energy industry. Karen has also edited the Construction Industry Law Letter, or KIL, for a number of years now. I'm very pleased to say that Lucinda became a partner with us at the beginning of May this year. She's worked as in-house construction litigation counsel for a manufacturing and engineering business, which gives her an added edge when it comes to considering the commercial context within which our clients operate. So in short, they're both perfectly placed to spend the next 30 minutes or so discussing with you some of the practical issues surrounding the termination of contracts here and now in 2020. But without further ado, Karen, over to you.
Thank you, Jeremy. And thank you to our audience for joining us today. I can get the slides to work, I will. Right. Today, what Lucinda and I plan to talk about, firstly, the right to terminate, firstly at common law and then under the contract. Secondly, the consequences of termination, both legal consequences and some practical steps you might want to consider when considering termination. And finally, Lucinda will look at the Corporate Insolvency and Governance Act 2020, which was very recently put into law, and in particular, the consequences on termination. And then following that, we'll have a short Q&A. I'll now hand over to Lucinda, who will start us off on common law termination.
Good morning. So, contracts can be terminated at common law by the acceptance of a repudiatory breach. What that means is that party A has committed or is clearly going to commit a fundamental breach of the contract that is so significant that it appears party A does not intend to be bound by the contract anymore. Party B then has a choice. It can elect to carry on with the contract and claim damages for breach from party A, or alternatively, it can say enough is enough, it can accept the repudiation, end the contract, and claim damages arising from the termination. If the repudiation is accepted, the contract comes to an end. That all sounds very straightforward, but in practice, it poses some challenges. The real risk is that if the party attempting to terminate gets it wrong, its attempt at termination is itself a repudiatory breach. The other party can then decide to terminate or not and to claim damages. Now, it's not unusual for there to be both claims, both party bringing a claim for repudiatory breach. One starts a chain and then the second party says, well, actually, your attempt at this is a repudiatory breach, so I'm going to claim against you. And the fingers point in both directions. And that happened quite recently in 2017 in the case of ICI and Merit. And that's quite a good example if you have time to have a look at that one. So to terminate successfully and make repudiatory breach work for you, there are two things that you really need to get right. First of all, you have to make sure that the breach is sufficiently serious to justify termination. It needs to be one that goes to the absolute core of the contract. Now, that is assessed objectively, and as you can imagine, is very fact dependent. And unfortunately, that means it's not always easy to determine if a breach meets the criteria. Just to give you some flavour, though, of what has and has not been considered to be a repudiatory breach in the past, a repudiatory breach by a contractor has included failing to start work at all or abandoning site during the course of the works. Delay, however, generally isn't a repudiatory breach unless time has been made of the essence or something material has happened to suggest that it is much more serious than a usual delay. An employer repudiation could be the employer preventing the contractor from working again at all by not allowing the contractor access to the site, or before the contractor's even started, taking away work and giving it to somebody else to do. In all those cases, the suggestion is that the party in breach doesn't want the contract to be performed as was intended. Late or underpayment by the employer is quite a tricky area. Generally, it isn't a repudiatory breach, but it could be the case that the cumulative effect of many examples of failing to pay could amount to a repudiatory breach and demonstrate an intention not to be bound. Or you could get a situation where non-payment of the majority of the total sum, thereby causing harm to the receiving party, is enough to constitute a repudiatory breach. But again, in each of those cases, it's going to be very, very fact specific. The second thing to get right is the timing. The right to terminate, once it's arisen, does not run on indefinitely. If the injured party acts in a way that is consistent with enforcing the contract, for example, by letting it run on for a year or more, or by implementing the provisions of the contract and acting as if the contract was still in place, then its behaviour will have affirmed the contract and its conduct will have demonstrated a choice to continue and not to terminate. So whilst considering its options, the injured party needs to expressly record that it is entitled to terminate and reserve its right to do so. It should also avoid taking steps that are consistent with operating the contract. If that's unavoidable, for example, a notice might need to be issued in order to preserve some right or entitlement, then that step needs to be taken expressly without prejudice to the right to terminate. And even then, if you can avoid it, it would be better to. It is vital, really, to make that decision quickly. Otherwise, the right is going to be lost. So common law termination is an option where there's a significant breach and you can move quickly, but it does carry these risks. The termination itself is generally effected by a written letter and it generally will have immediate effect. But what happens next? Well, in ICI in Merit, Mr. Justice Fraser confirmed that the existing rights and obligations will remain in place. So if you have accrued rights and claims, then they will remain, but future performance will come to an end. So neither party has any future obligations to perform. Again, that sounds quite simple, a nice dividing line between what's happened previously and what is going to happen or not going forwards. But in practice, it actually poses some dilemmas because there is very little guidance about how you manage the actual practicalities. There's a construction project live on site. There is a whole heap of materials. There's a whole lot of scaffolding, for example, may still be on site. How do you deal with unpicking and unravelling all of that? Likewise, who works out and how do you work out who is going to be paid what? There is no route map for all of these things. And the likelihood is that there is going to be a bit of a fist fight over monies and who should be paying them. So whilst repudiatory breach can offer a way out, given these uncertainties and the scope for risk that it presents, it is perhaps best kept for when there isn't a contractual right to terminate or as a backup to a contractual right to terminate if for any reason the contractual right might fail or poses risks of its own. And on that note, I will hand over to Karen to talk about the contractual side of life.
Thanks, Lucinda. Before considering contractual termination in detail, I think it's just worth pausing and asking, why do we think about termination? Why would we terminate? And certainly from a contractual point of view, if you go back to the start of the contract and you think about the bargain that the parties entered into, normally something has happened that is so fundamental that changes that bargain that's why a party wants to get out of the contract, and that's why you start thinking about termination. So those could be quite big events, things like insolvency, which currently is slightly different because of the Corporate Governance Act that Lucinda will come on to. But traditionally, insolvency is one of those big events. But other events too, fundamental default in performance, that can be an issue that might make you think we'll never get this job completed, we're just going to have to terminate it. And because of that, and I think because of the recognition that in some way the bargain is changing, most standard forms, and indeed most complex or sophisticated contracts, will contain a regime relating to termination, and there will be a very detailed set of provisions that set out what happens and when and how you effect termination. In construction contracts and in contracts as a whole, you tend to see two types of provision. Provision for what we call termination for convenience or termination at will, and provision for termination in the event of a default. And typically, you will have different consequences arising from those sorts of circumstances. So a termination for convenience clause is likely to be slightly fairer in what happens next, or I say fairer, but perhaps the fact is, if an employer decides to terminate for convenience, then the likelihood is that the contractor will be able to recover its lost profit on the contract for obvious reasons. If there is termination due to an event of default, then effectively what you're saying is that there's been a breach of contract. And so the contract will recognise that damages of some sort are going to have to follow. It's important to recognise, and I think Lucinda's touched on this, that the contractual provisions do not necessarily displace common law rights. So you can have the right to terminate contractually, as well as the right to say there's been a repudiatory breach. But you have to be very, very clear in your exercise of those rights. You cannot try and terminate a contract under the contractual provisions and then use a different or an inconsistent repudiatory breach. You do need some consistency in your approach. But I think the other thing is some contracts do try and displace that common law right, and it can be displaced, but only with very express wording, and there is case law to that effect. So whilst there may be some arguments about whether or not you can use the common law rights as well as your contractual rights, you need to go back to the contract and see if the common law right is expressly excluded. In terms of what those provisions might look like, the likelihood is that you'll have a set of provisions that allow for termination by the contractor and a set of provisions that allow termination by the employer. The events that allow that termination are likely to be different, and as most contracts are generated by the employer, you're likely to have many more provisions allowing for termination of the contractor by the employer than of the employer by the contractor. Typically, the type of clauses that or the type of events that allow you to terminate an employer's role under the contract, or that look at employer default, are things like insolvency or repeated or persistent failure to pay. The list of events of default for a contractor, by contrast, is likely to be slightly longer. It will obviously, I think, also include insolvency, but will include other things related to performance. If there may be rights to terminate related to liquidated damages, to delay, to various other events that might occur. The other thing to consider when looking at those sorts of provisions is that whilst you might have events of default, there are normally two ways of dealing with those events of default in these sorts of clauses. One is to say that if that event of default happens, then you can immediately terminate the contract. And those are sort of, I think, the very, very serious types of default, quite similar, I think, to what Lucinda was talking about with the repudiatory breach. The other type that you get is where a default occurs and one party must give notice to the other party and give the other party the opportunity to cure that default. Normally it's a period of maybe 14 or 28 days. And only if that default is not cured can the contract be terminated, normally by serving another notice. Ultimately, these are quite complex provisions. They will often be very heavily negotiated, and what they might say, the circumstances that you might be able to rely on, and the consequences that might happen will very much depend on the wording of the contract, which leads me on to my next slide. Before you terminate, you've got to give an awful lot of consideration to it. It's a really big thing to do, and something that really shouldn't be undertaken lightly. The first thing that I would say to a client who's in that sort of situation is check your contract, then double check your contract, and then recheck it again, and let's just work out every single thing that it says that we need to be aware of if we're going to go down this route. So, first of all, have the circumstances required, the circumstances arisen that you need in order to terminate. Are they going to arise? Is this something that you're thinking is going to happen in 2 or 3 weeks' time? What are we going to do about it? Then we need to look at the notice provisions. What sort of notices need to be given, in what form, to who? Notices are really important. You need to serve your notice to terminate. You might need to serve one notice followed by another notice, as I said, in a sort of a cure and default situation. So what sort of process are we looking at? Is it something that's going to take effect immediately? Is it something that's going to take effect in 2-3 weeks' time? What is our timeline for this? The default and cure I've talked about. We need to understand that, and a wider issue to understand on default and cure is what actually is the cure. Not every breach there is not an obvious cure for every breach. So is what the contractor or the employer has done to remedy the cure enough? Is it sufficient? Have they got themselves over the line? So we need to consider what we would believe to be enough to take away the right to terminate. And finally, what does the contract say about consequences? And I'll look at that in a bit more detail later on in this talk. But again, it's the advantage that a contractual clause should have over common law is that it should give you a good contract, will give you a good framework over what happens with things like site, securing the site, equipment, plant materials, subcontractors, collateral warranties, all that sort of thing. That's what you should be looking for. And if you've got that, at least you've got a framework that you can work to. So once you understand what the contract actually says, then you need to consider, right, I understand that. Do I still need to terminate? Do I still want to terminate? Is that still the right course of action? So the first thing I think you need to think about is your relationship with the other party. If you terminate, are you actually just going to blow that relationship to smithereens, and do you want to do that? Have you been working with this other party for years? Are you planning to work with them in the future? You do need to have a think around that. Think about whether it's more profitable to continue with the contract. It may well be that as a result of termination, you're not going to get paid for a long time because there'll be a divvying up exercise that will take time and people will get entrenched in a dispute. If you've got maybe one or two milestone payments that you think will be paid in the next few months, maybe you're better off just waiting for that to happen. Think about the other rights and remedies that you might have from an employer's point of view. You might want to say, well, look, I've got a bond here. I could call that, although that may actually be just as detrimental to the relationship as terminating. But you do need to consider what other options are open to you. And of course, you need to consider whether you can actually sit down and negotiate the issues that are between you. And generally in a termination situation, that is in train, or negotiations will come to the end and one of our clients is saying we simply can't take it any further. And the other side to that is dispute resolution. Is this going to end up in a dispute? Is that what you want? Is this something that is capable of being perhaps adjudicated? That may be a better alternative. It may be something that you can get a quick decision on in maybe 6 or 8 weeks and the parties will be able to move forward. So it's important to think about all of these things before you consider whether or not to terminate under a contract. So moving on, the slides, onto the consequences of the termination. There are a number of legal consequences. Lucinda touched on the first one, which is the obligation to perform main contractual duties comes to an end. So you are no longer, as a contractor, obliged to undertake the work, and the employer is no longer obliged to pay you. There will always be some terms that survive the termination of the contract. The obvious ones are governing law and jurisdiction, but most well-drafted contracts will set out a set of clauses that survive termination. And they will relate to things that are very important to the parties that carry on existing once the contractual relationship has come to an end. So it may be things like confidentiality or intellectual property rights. The other thing that you need to take into account are accrued rights. And again, I think Lucinda touched on this. But if there has been a breach of contract prior to termination, then your right to sue on that breach or to recover the damages from that breach is accrued. You retain that right following the termination. I'm looking at the clock, so I'm going to go very quickly. But one case that is very much being discussed at the moment is a case called Triple Point against PTT, where liquidated damages were considered, have generally been considered to be an accrued right, but the Court of Appeal has recently said that following the termination, liquidated damages in that case were not considered to be the accrued right. Instead, the right was general damages to delay. That case is going to the Supreme Court, and it'll be interesting to see what happens with that. But again, you need to consider what those rights might be following termination. At common law, a party alleging repudiatory breach may claim damages for breach of contract. That will include loss of profit. As I've mentioned previously, under the contract, your entitlements should be set out. So you need to look at those and understand what they are likely to be. They will often mirror the common law. And the other point to make, obviously, is what Lucinda said: what happens if you terminate wrongly? And if you do that, then the other party can say that there's been a repudiatory breach. Some contracts, for example, the IKME Red Book, says, in fact, if you repudiate wrongly, certainly in a purchaser situation, then instead of it being a repudiatory breach, instead the provisions for termination for convenience apply. So again, you need to be aware of what your contract provisions actually say. And just finally, some practical things to take into account, but which are really, really important. And one thing I would always say is you need to have considered and planned for these before you terminate. Firstly, preparing the ground for termination, sit down and plan what's going to happen. Sit down, make a timeline, work out when the termination will happen, what will be the result of it. Do you need to notify anybody? Do you need to notify investors? Do you need to talk to anybody about it? That's very important. Once you do terminate, some of these points, some of the issues that do arise from a purchaser point of view or an employer point of view, securing the site, disorderly behaviour, it does happen. People can get very irate when they're told to leave the site immediately. From a legal point of view, one thing you can do is set up injunctions ready to go if necessary to mandate people to leave the site. You can set up a plan to make sure that you secure the site safely. That's very important. Plant equipment and materials. What are you going to do about those? What does the contract say? Who takes those? Do you have to take plant and equipment off site? Where are you going to store it? You have to do that. Documentation and data. Who owns what once you get to termination? What do you have to give? What are your obligations? Who has to give documentation to who? Who has copyright? All of that needs to be sorted out, and you need to have a plan around that. Payments. If you're a contractor, when you're next going to be paid. If you're an employer, when you're next going to have to make a payment. Notices to third party, particularly in finance projects. Are lenders involved? Do you have to give notice to lenders? Do lenders have step-in rights to the contract? There are some contracts where a contractor can, once giving a notice of termination, then have to wait 90 days to allow a lender to step in. So understand that position. Subcontractors, what are you going to do with your subcontractors if you terminate? Can you terminate their subcontracts? Are they going to make claims against you? Are they going to enter into contracts with the employer? What's going to happen with their final accounts? That all needs thought. Dispute resolution, are you going to end up in a dispute? How are you going to manage that? What do you think? You need to think about the merits of that dispute, how that might play out. And finally, and I've mentioned it before, bonds. Will a call be made on a bond? Do you want to make a call on a bond, depending whether you're contractor or employer? All of that needs to be considered. So, in summary, termination should not be taken lightly. There's an awful lot to consider. And with that, I'll hand back to Lucinda to talk about the latest legislation.
Thank you. Yes, there's a lot to do. So time for a little bit of brand new law. So at common law, as Karen touched on a little bit earlier, you can't terminate because the other party has become insolvent. It isn't a breach of contract in its own right. So most contracts add it in, certainly our usual construction standard forms do. Now, the Corporate Insolvency and Governance Act, we've missed a word on our slide, apologies, came into effect in June, and it interferes with contractual provisions around insolvency quite significantly. So it's important to understand what all of this is about and exactly how it is interfering. It's been introduced, this Act, as part of the government's package of measures to deal with businesses following the COVID-19 crisis and to try and give suppliers facing financial difficulties a little bit of breathing space, that's the government's term, from its creditors. So the idea being that this will help them to trade through the difficult times or at least make a rescue more viable. So it introduces various changes. For example, there's a temporary ban on winding up petitions, but there is too much for us to cover today, so we are going to focus very specifically on termination. So Section 14 of the Act introduces a new Section 233B to the Insolvency Act 1986. It applies to contracts for the supply of goods and services, and that is going to include construction contracts because they most certainly are contracts for the supply of services. So the Act is going to apply to our world. If the customer becomes insolvent, so the customer becomes insolvent, the supplier cannot exercise a right to terminate that has already arisen but not been actioned during the insolvency period. So you need to get in quick before the insolvency happens. Nor can the supplier use contractual provisions to terminate on the grounds of the customer's insolvency. Any contractual provision that allows them to do so will be inoperable. So in practice, this means that the main contractor cannot terminate the contract with its employer because of the employer's insolvency. For example, it's gone into administration or liquidation. Nor can a subcontractor terminate its contract with an insolvent main contractor because of insolvency. Instead, the supply of goods and services should continue in line with the contract. Conversely, the contractual rights of the customer to terminate if the supplier becomes insolvent remain intact. Word of caution though. To terminate on the grounds of insolvency, the nature of the insolvency event being suffered needs to fall within your contractual definition of insolvency. Now, the Corporate Insolvency and Governance Act introduces a new insolvency procedure involving a moratorium, and that is probably not covered by the contractual definitions that are in most contracts, unless they are drawn extremely widely. Also, whilst a winding up petition is under some contracts a ground for termination on basis of insolvency, winding up petitions are currently banned. So that is not going to be a route to a contractual termination for insolvency for the time being. So that leaves us with a bit of a problem if you're the supplier, because ultimately the benefit of the contract to the supplier is its right to be paid. And obviously the insolvency of a customer is going to impact on the likelihood of payment coming through. And many contractors, subcontractors and suppliers are not going to relish the prospect of incurring costs of labour, plant, materials and all the usual costs as they continue with their work, knowing there's a good chance they're not going to recover their costs from an insolvent customer, let alone any profit. However, if you stop supply or you leave site, then you're facing some significant adverse repercussions. You could find that you're paying damages for delay. If you're under delay obligations and you're not meeting those progress milestones, then you are likely to be liable for delay. It may be, if your default is serious enough, that you are going to be liable for repudiatory breach and the customer can claim damages from you. Or you could find that you fall foul of another new provision from this Act, which is that suppliers may not do any other thing on the grounds of the customer's insolvency, which is slightly too wide for us to cover in the time we have available this morning. But what it means as a package is that as the supplier, you've got to keep going. Otherwise, you are facing some significant risk. Now, there are a few things that you might be able to do to minimise this risk. And here are some of the ideas that we've come up with. So option number one is to act very quickly. If you think as supplier there is a likelihood that your customer is going to become insolvent, then it may be that you can act or find a reason to terminate promptly now before it actually gets to the point where it is formally insolvent. So that, for example, might include the filing of a notice to appoint administrators, so you could get in quick before the administration is actually in effect. That's one option. The second option is to check if you fall within the exemption. So the Act does allow what it describes as small companies to be exempt from these provisions. So if you meet one of three criteria, then you're exempt. And those criteria are having a turnover of less than 10.2 million, net assets on the balance sheet of less than 5.1 million, and less than 50 employees. So if you can tick two of those boxes, then you're okay. You can carry on relying on your contractual insolvency termination provisions. A third option is to actually come to an agreement. So this in practice might be a more straightforward option for many parties. If the insolvency practitioner who's been appointed agrees that you can terminate the contract, then you can carry on and operate those clauses. Now, whether or not they agree, of course, is going to be very dependent on how significant the supply is and whether or not the customer wants it to continue or the insolvency practitioner wants it to continue. So again, it's difficult to know without knowing the certain circumstance of any project how useful that's going to be. Another option that the Act provides is an application to the court on the grounds of hardship. So a supplier with the termination provisions in the contract could toddle off to court and say, please could we have permission to terminate this contract because it's causing us financial hardship. You need to be suffering hardship to make that work, but you also need to be able to justify the time and expense of going through that application process, which in some cases will be worth it, but in many others won't. And then we come on to other grounds. So it may be that actually the practical thing to do is to find another reason to terminate. The difficulty here is, as Karen touched on already, if you are in the supplier's position, it's likely that your options for termination are more restricted than the customers are. So there weren't many grounds for you to terminate in the first place, and insolvency was probably one of the most important to you. In its absence, you need to rely on something else. Now, the likelihood is that that will be a default in payment, perhaps long term, and that might give you scope to argue that you can bring the contract to an end, depending on your particular contractual provisions. However, you've got to wait for that ground to arise, because as I said earlier, if that opportunity arose before the insolvency, it's too late. You have to use it or lose it before the insolvency, or you have to wait for the grounds to arise again subsequent to the insolvency. So it is a little bit tricky. The other option is to try and reduce costs. Now, again, how practical this is in any given scenario will depend on the facts of the situation. But if it is possible for you to meet your supply obligations at minimum cost to yourselves, that will help perhaps, at least in the interim, until you can find a ground for termination. And finally, and looking ahead to future contracts, other things you can do to prepare include the following. You could ensure, and you should anyway, ensure that the due diligence you carry out on your customers is very, very thorough, and that you are comfortable they are good for the cash before you start to supply. Be very wary of those who do not look like they're in a comfortable position. Or if you want to proceed but you're concerned about the risk, try breaking the supply into smaller packages, perhaps. Again, sometimes more possible than in other situations, so that the risk per contract is smaller. Also, when you are negotiating the contracts, it is really worth having a look at the termination grounds now, particularly as a supplier where your options generally tend to be limited, and trying to ensure both that the definition of insolvency is wide as it possibly can be, so that you can capture the early stages of the processes. The second thing that you might be able to negotiate is to just try and include more grounds, so that if you can't rely on the insolvency ground, there is more opportunity to use something else. And on that note, that brings us to the end of this presentation. Move the slides forward one. And Jeremy, we can answer any questions if there are any.
There certainly are some questions. So thank you very much to the two of you for your discussions so far. I begin with a slightly apologetic question. For someone who just missed the very first part of what you were saying, Lucinda, when you were talking about repudiatory breach under the common law. And the question, I just wanted to sort of seek clarification what you're saying about delay, and whether or not delay was generally a good enough reason for termination when we're talking about repudiatory breach.
No, generally it's not, unfortunately.
Yeah, I mean, to be fair, that's what the questioner thought. They were just coming in as you were speaking. There was another question about repudiatory breach. You were sort of talking about how repudiatory breach goes to the core of the contract. But one of the more annoying things sometimes for a contractor with subcontractors or an employer with a contractor, you get a series of minor breaches. Can they add up to a repudiatory breach?
They can, it's possible, but again, you have to look at the facts of every single case, and it is going to be very fact dependent. If that series of minor breaches creates the impression that the defaulting party really doesn't intend to be bound by this contract, then they can add up to be enough. But I think they have to be really quite persistent to get over the hurdle.
Okay. Lucinda, you were talking about the new law, Corporate Insolvency and Governance Act. A couple of people have homed in on one of the bubbles from your final slide. Wondering if the government's actually issued any guidance on what hardship actually is.
No, No, I mean, rather unhelpfully, there isn't much. It's actually an existing principle because there's already legislation that prescribes for certain services to continue even in the event of a customer's insolvency. So it's already an existing principle, but there is no guidance or case on it at the moment. So no one's really sure what it means, but it's inevitable that the payment may be delayed or not forthcoming. So just an absence of payment on its own is not going to be enough to qualify it as hardship. I think it is going to be necessary to show that it is leading to financial pressure and strain and having a real adverse impact on the supplier's books.
Okay, thank you. I think there's time for just one more question. Termination obviously is quite final, but how do you avoid ending the relationship between the two companies concerned when you end the contract? Is it possible to terminate a contract and then still work together afterwards? I mean, if it is possible, how would you do it?
It is possible. I've come across projects, and so has Lucinda, where that has happened. I'd say it's probably more the exception than the rule. It is a way of putting a hand grenade under your relationship, but it depends on the scenario. I mean, there may well be circumstances where both parties accept that that has just been a difficult project, but they're working together on a lot of other projects, and they will carry on and work together to do those projects. It also, to some extent, I think, depends on the personal relationships within the companies involved. Lucinda, I don't know whether that's your experience as well.
It is, yeah. I think a lot of that is going to come down to how it's managed as between the people in the different businesses, and perhaps the reason sitting behind the termination and how adverse that is.
I mean, speaking for myself, I agree with you both. I mean, I think one of the most important things when it's termination, or also when there are difficult circumstances on any project, perhaps particularly at the moment, given all the sort of, the situation that we're all finding ourselves in, is the importance of communication. And by that, I actually mean talking to people, not sending emails. Face-to-face talking to people, maintaining and building and working to maintain relationships is so important, and can help avoid disputes, and hopefully help avoid disputes reaching the level of where you come to termination. But thank you very much, Lucinda. Thank you, Karen. So very helpful contributions today. And thank you all for listening and contributing with your questions. Just leaves me to say goodbye and look forward to seeing you again in about 3 or 4 weeks' time on Thursday, 10th September, when my colleagues Jatinda Garcha and Edward Kolkoff will be looking and talking about negotiating construction contracts, hopefully post COVID-19. So hopefully enjoy the next 2 or 3 weeks, and we'll see you then. Goodbye.
Bye.